put mine over. Oh, okay. Well, let me log you in. Well, you probably want to log yourself in, right?
I can have like Facebook on the phone.
Check one.
I need
Check
to pull
one.
it up. We're just gonna avoid the what's your opinion? We want to avoid the what's your opinion. See one of those things that goes viral where people are talking off. They think they're off mic.
Oh yeah. Are we muted now?
Yeah, he said we're muted basically.
Check, 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 check.
Did everybody get? Well, I mean, you just got this. Did you get to send any resources? That's okay. I sent quite a few. I sent a bunch of links. I mean, I didn't cite it. Put it in citation.
Can you set this where that screen won't time out? Because it'll time out. There's a setting for that.
Even if it's going live. I mean, when it gets streamed.
I don't know.
Usually, if it's streamed, they don't bump.
Oh, okay. I don't know.
E-G-A-L-A-D-O.
What's your title?
Professor of Government and History.
Janice Hicks. Vice President, Institutional Effectiveness.
What was your last name?
Hicks, H-I-C-K-S.
Thank you. Timothy Clark, C-L-A-R-K. Professor of Communications. I think we might be about.
Looking for a change? Your growth continues at Odessa College. OC can help you learn or develop skills so you can advance in today's workforce. You could be eligible to receive up to $2,500 per semester toward your tuition and fees through the Texas Reskilling Grant, making tuition free. Train for high demand and high growth job fields, or go for that college degree you've always wanted to pursue. Call Odessa College today to find out how the Texas Reskilling Grant can help you.
Before I continue, my name is Daniel Regalado. I have a PhD from Texas Tech University, authored the first Texas government OER book, and spent 4 years in Marine Corps Infantry. Also, I'd like to thank Dr. Williams for your support on this project. Kim McKay, Dr. Henderson, thank you for your vision and leadership on this. Alexis, your team, marketing team's amazing. I do have a statement I would like to read. Our community is experiencing an increase in positive COVID cases. As such, we remind all of you that the best way to protect yourselves and others is to wear a mask, keep your distance, wash your hands, and sanitize work and learning spaces. Thank you to the panelists, which I'll introduce here in just a sec, the audience both online and here. I just want to make sure we know that the purpose of Order in the Court is to educate. We are going to provide a nonpartisan, non-ideological approach at teaching you the facts and some what-ifs. So because of that, we're going to be talking about some controversial topics. We have some rules of engagement. Everybody has an opinion, but we need to respect everybody's opinion because today we're going to be talking about the Dobbs case, which I'll summarize here in just a sec. Before I move on, let me introduce the panel. Start to my left and move onwards. Dr. Janice Hicks has served in various academic and student affairs capacities at several types of institutions, including universities, community colleges, and a medical center. In 2016, she earned a PhD from the University of North Texas in Higher Education Administration with emphasis on community college leadership and teaching and learning in the academy. Prior to that, she received her Bachelor's of Science in Educational Psychology with a minor in Counseling Education from Mississippi State University and Master of Science degree in Counseling and Student Affairs Administration from the University of Central Arkansas. Dr. Hicks currently serves as the Vice President for Institutional Effectiveness at Odessa College. Let's give Dr. Hicks a hand, please. Next, we have Professor Clark. Timothy Clark serves as a speech and communications instructor at Odessa College. Prior to that, he has worked in student services as the assistant registrar, a student success coach, and the executive director of enrollment services. In 2019, he received his Master of Arts in Communication from Arizona State University and is also a graduate of Odessa College and Permian High School. Go Broncos. Smack talking in there. Here at OC, he teaches media literacy among other classes and will be serving on the panel today in reference to current events and media overload. Please give Professor Clark a hand. Next, we have Professor Zimmerman. Autumn Zimmerman is a historian whose primary research is in discrimination. She received her master's degree in history from the University of Texas at the Permian Basin in 2021. Her thesis discussed discrimination in competitive speech and debate and analyzed how discrimination, gender-based, race-based, and socioeconomic-based in microspheres leads to discrimination on a macro level. She received bachelor's degrees in history, speech communications, and quantitative analysis from Kansas Wesleyan University in 2019 and was a 3-time national debate champion. So if you're going to ask a question, you probably want to avoid asking her one. She has also interacted extensively with politicians both at the state and federal level. Zimmerman now teaches American history at Odessa College. Please welcome Professor Zimmerman. And last but not least, we have Professor Finley. Glenn was conferred a BA in telecommunications from Texas Tech University in 1977, an MA in history from UT Permian Basin in 1991, and another MA in political science from Sul Ross State in 2000. He has 2 grown children. His oldest, Jessica, is a graduate of Odessa Permian High School, once again, go Broncos, and Texas State University in San Marcos. She currently lives and works in Pflugerville, Texas. His youngest, Robert, is also a graduate of Odessa Permian and is currently employed as a ground specialist here at Odessa College. Even with retirement, Glenn continues to maintain his interest in American politics as well as American history. Let's please welcome Professor Finley. So let me start off with a summary of Dobbs. So you might have heard in the media Dobbs case, Dobbs versus Jackson, or Dobbs versus Jackson's Women's Health Organization. These are all the same thing. I just want to make sure we're clear on that. But basically, as you've been hearing, the Dobbs case overturned the Roe versus Wade and the Casey case, which we'll talk about here in just a sec. And basically what the Dobbs case ruled was that abortion was not a constitutional right guaranteed in the United States Constitution. And where it came from is Mississippi had passed the state law that basically banned abortions after 15 weeks. Well, this was questioned in regards to the constitutionality of it, went up to the Supreme Court, and the Supreme Court, again, I told you the ruling, but basically said, we're going to stay neutral and we're going to let the states decide on this matter. Now, in regards to Texas law right now has banned abortion, but we do, Texas does have an exemption if the woman's life is endangered, which we'll touch on more. But before we go on, I think a lot of us need to make sure we understand the Supreme Court, the role and the history and how they even received that power. So Professor Zimmerman, as our historian, if you'll tell us the history of SCOTUS and judicial review, please.
Most definitely. History is everybody's favorite topic, right?
Absolutely.
So the founding of SCOTUS really goes back prior to the Revolution, because during the Revolutionary period, a lot of the soldiers in Great Britain and a lot of the governmental facilities in Great Britain didn't really allow for due process and allow for the right to a trial for many of the colonists, and this really frustrated the founders. So when the Constitution was put together, they ensured that a clause in the Constitution and a specific section in the Constitution, which is Article 3, would create a judicial branch so that trials and people's rights could be defended. So ultimately, the Constitution sets up the right for a judiciary, but doesn't set up terribly many descriptors or sort of directions for that court to take. So the Judiciary Act of 1789 was put forward in order to delineate some of the responsibilities of the Supreme Court. The Judiciary Act was actually the first act that was observed by the Senate in the United States. And so the Judiciary Act basically sets out what the Supreme Court is going to be looking at, what powers it's going to have, those kinds of things. So the establishment of the federal judiciary under Article 3 of the Constitution really, for the first 100 years of its life, was sort of straightforward and set in its ways because of the Judiciary Act. But in 1801, there was a bit of conflict inside of politics. So John Adams was exiting the presidency and lost the election of 1800 to Thomas Jefferson. He was a bit frustrated about it. So Adams, in a ploy to make things a bit more difficult for Thomas Jefferson and his presidency, decided that he was going to pass an act in 1801 that would allow him to expand courts, appoint more judges, appoint more justices of the peace, those kinds of things. Before he left office, around 2 days before actually, he appoints all of these other individuals and the Senate approves them, but they don't get their commissions, which means that it's not legal for them to maintain those offices and to take up those positions. Now, the caveat to all of this is that these individuals are of the opposite political party of Thomas Jefferson, so they're supposed to make things a lot more difficult for him than meets the eye. So Marbury, who is one of the individuals who has been appointed by John Adams and who has been approved by the Senate, is appointed as a justice of the peace in Washington, D.C., and ends up not getting his commission. So the new Secretary of State, James Madison, he approaches and asks for his commission, and Madison refuses to give it to him because, of course, they don't want members of the opposite political party to obtain those offices. So eventually, Madison and Marbury end up taking the case all the way up to the Supreme Court, where it's decided that ultimately not giving the commission was illegal. However, Because Marbury brings up the court case and brings it to the Supreme Court, they determined that this is something that's outside of Article 3 of the Constitution, that it's vastly expanding what the judiciary is supposed to be capable of doing and the responsibilities for the Supreme Court, essentially. So in Marbury versus Madison, they established what's called judicial review, which is the right for a law to be deemed constitutional or unconstitutional by the Supreme Court.
Thank you. So we have basically the Supreme Court now being the official interpreters of the Constitution now, which as you saw with the Dobbs case. Professor Clark, I'd like to ask you to help me address this question. We had a question from Facebook, and it said, how can we claim to live in a democracy when 64% of Americans support Roe versus Wade? I want to make sure we understand that America is a democracy, but we're what's called a representative democracy, which in other words is also called a republic, where we choose members of Congress and the President of the United States to make decisions for us. Those in turn pick Supreme Court justices, and then of course those Supreme Court justices make decisions on your behalf. But with that being said, many political scientists have argued that many foundations of a democracy, but one of them being public opinion. And of course, public opinion is what the people think. So Professor Clark, could you tell us what the data says about abortion?
Most definitely. There are a ton of research going on, a ton of surveys that are going out right now, and this is something that is constantly changing. With the 64% that you mentioned, the most recent thing that I have found on Pew Research is 61%. When we're talking about the number of U.S. adults who say abortion should be illegal versus legal, 61% as of 2022, start of July, were in favor of it being legal, while 37% were in the illegal in all cases or most cases camp. When we talk specifically about the decision to overturn Roe v. Wade, this data comes directly from Pew Research, but this is very interesting to me. This is going to be Roe v. Wade disapproval among Democrats and versus Republicans, and then men versus women. But 57% disapprove of the overturning, while 41% approve of it. When it comes to men, 52% of men disapprove of the overturning of Roe v. Wade, whereas women, it is quite a bit higher at 62%. The Republican versus Democrat, as far as who signified which party they generally vote for, it kind of goes as you would expect. So about 29% of Republicans disapprove of the overturning, whereas Democrats, it's 82% that disapprove. 8 in 10 Democrats and Democrat-leaning independents disapprove of the court's decision. I found that interesting because they are more on the moderate side as far as on the leaning side. When we get into this particular research, it was looking at the religious divisions, but more importantly, I wanted to hit a few things within it. Deep religious divisions in views on abortion, percent of those who say abortion should be legal in all cases. When it comes down to those that were married, living with their partner, 59% think that it should be legal. And those that were not married or not living with a partner, 67% think that it should be legal in most cases. There is some breakdowns on here as well, and I'm not sure if the people at home are seeing this particular statistics, but we will make it available for a PowerPoint, and I think that we will have a QR code available for you to check here before too long. This is on the US level. We're going to get into the Texas level here in 1 second. Roughly 6 in 10 Americans believe it is not possible to go through daily life without having their data collected. When I was looking through this and talking through the cases, one of the things that keeps coming up is the privacy side of things, and we talk about HIPAA. And really, there is not a ton of good research out there at this point that can be validated. Talking specifically about this case that is recent, most everything I could find is quite a bit outdated, but what we do find it in and what we talk about in my media literacy class a lot is how many companies are tracking you based on what apps you use, based on what TV shows you're watching, based on who you do business with on a day-to-day. And I thought it was interesting, 6 in 10 Americans believe it's not possible to go through daily life without having their data collected. And not many students, not many people are aware of what people are doing with that data. Also on this page, we have the confidence in the Supreme Court as of 2022. It is at an all-time low with 25% having confidence in the courts. We get into the state of Texas, and this is all data directly from the Texas Health and Human Services Department. According to Texas Health and Human Services, in 2021, there were 50,532 induced terminations of pregnancy, and it's got a breakdown by age. We'll look at it a little closer in another chart format, but what's important to notice is the majority of these are occurring between the ages of 20 and 29. You can see on here one at 11 years or less. We'll talk about a case in Ohio later on that was in the news quite a bit recently. 12 to 13, there were about 30 cases, and then the majority of them come through from 20 to 24. In Texas, we break it down. The majority of those that had an induced termination of pregnancy were unmarried. The race and ethnicity breakdown, majority Hispanic, as the majority of Texas is at this point as well, so those numbers weren't too shocking to me. I did find it interesting to include in here, based on what we're talking about, those that had a procedure done in a medical place, 50,532 survived the process. 0 did not survive, so nobody passed away from having this operation done in a medical facility. And then the last couple of things, the majority of the procedures for Texas residents happened at 8 weeks or less. Then going forward, we've got 9 to 10 weeks, about 3,000, 11 to 12, and you can see we'll get into the trimesters and where they hit at some point, but the majority of these are happening in the first trimester on this, according to the Health and Human Services. This is just going to be another couple of breakdowns of what the last 2 decades will look like. If I can get you to go ahead one more, there you go. Thank you. The biggest year-to-year decrease in abortions occurred in 2014. This is when a law went into place in Texas. They required doctors performing an abortion to have admitting privileges at a hospital within 30 miles of the abortion facility. There was quite a bit of a drop from 2000 to 2014. And as you can see, it's on the lower end historically as it is over the last 2 years. Again, by age, 50 to 60% of those abortions happen between people that are 20 to 29 years old. And then in the weeks of pregnancy, the majority of these are happening at 10 weeks or earlier, and then it kind of goes from there. This very, very last page is a research that was done by the University of Texas as part of a projection polling campaign. This one is going to tell us those that are the total share in support of access. About 82% of Texans that are likely to vote think that abortion should be accessible or obtained if the woman's health is seriously in danger. If the woman becomes pregnant as a result of rape, there is an 80% support. The woman becomes pregnant as a result of incest, there is about a 78%. Strong chance of serious birth defects, there is a 69%, and the family has low income, 57%. The woman is not married and does not want to marry, we're at about 50%, and the woman is married but does not want any more children, it's about 53% on the total share of the support on it. So really interesting statistics, but as you kind of mentioned at the beginning, the 64% number of people that are not in favor of this decision is kind of in line, and then Texas is actually kind of in line with those as well, which was very interesting.
Thank you. Just want to reiterate a couple things. Remember that this is non-ideological, so we're presenting facts, and no one's trying to change your mind in any way or other. But going back to the representative democracy and public opinion statement, this is why it's so important for, if you are eligible, to register to vote and go out and vote whichever way you want. But also, even if you're not eligible to vote, as I always tell students, you can still participate. You can still go out there, and even simply wearing a campaign button or anything like that is still political participation. So before we start getting into a little bit more details of Dobbs, once again, Professor Zimmerman is our historian. Will you tell us about Roe versus Wade and Casey? Because a lot of times we just hear Roe versus Wade, but we don't hear about the Planned Parenthood versus Casey case as well. Will you give us a summary on those two cases, please?
Certainly. So Roe versus Wade actually hits a bit closer to home for people from Texas because it's a case that originally occurred in Texas. Roe v. Wade was a case where a single woman brought a class action lawsuit into the courts because pregnancy in Texas could not be terminated unless the mother's life was at risk, and she did not want to have her baby. And so she ultimately brings her case to a 3-judge court that deems that she has the right to seek a trial at the Supreme Court level. When the Supreme Court evaluates Roe v. Wade, the Supreme Court basically has to balance states' rights and state intervention with women's rights and women's capability to have privacy and to choose whether or not to have a pregnancy full term. And so ultimately what they decide is that in 1973, 24 to 28 weeks is considered the point of viability for a fetus, and up until that point in time, it is okay for a woman to seek an abortion by federal law because of due process and because of her right to privacy, so the 9th and 14th Amendments, because she has the capability to hold that privately. And they divide pregnancies into a trimester framework. So the first trimester takes place from about the first week to 15 weeks, second trimester and third trimester follow. But basically, up until the point of viability of a fetus, it is okay to terminate it under the mother's jurisdiction. So they put into place a precedent for what's called the strict scrutiny standard when evaluating other state laws for abortion, because of course other states have some strict abortion requirements and some other states don't, and the states that have strict abortion requirements were capable of being put under that strict scrutiny sort of standard. And what strict scrutiny states is basically that in the court of law or in a regulation, it is necessary to achieve a compelling state interest for a state to have that law in place, and that they can't do it in any other feasible way, and they can't provide hindrances. So basically, it's a precedent that gets set that says if the state law prohibits something or impedes on somebody's rights, it has to have a justifiable reason to do so. And so the strict scrutiny standard in terms of Roe v. Wade basically says that you can't impede upon a woman's right to choose to have a pregnancy or to terminate a pregnancy up until that point of viability, and even after the point of viability if the woman's health is at risk or if she deems that she does not want to have that abortion. And the Constitution, according to the Supreme Court, upholds that because of the 14th Amendment and the 9th Amendment to the Constitution. So Roe sets up a standard that basically says that we have to evaluate pregnancy on a trimester framework, that up until the point of viability, abortion can happen, and it's protected by the Constitution, and even after that point of viability, it's up to the mother because she has health privacy and has the capability to privately handle those concerns. On the other hand, Casey versus Planned Parenthood is a case that arises in the Commonwealth of Pennsylvania, which is led by Governor Robert Casey, who enacted an abortion statute that basically required a wife to divulge information to her husband on her health if she wanted to get an abortion. States that children, if they have pregnancies and want to terminate them, have to have parental consent. States that a wife and a husband have to both consent for an abortion, and several other things, and that a woman has to wait 24 hours prior to having an abortion to have the abortion, so that she considers that sort of ramification before she actually goes through with the process. And so the Supreme Court, when it rules on Casey, rules basically that all of those things are okay, except for the fact that a woman shouldn't have to notify her husband if she wants to have an abortion, which is interesting. But the case actually goes a bit further, because instead of strict scrutiny, it puts an undue basis standard or an undue burden standard on court cases that deal with abortion. So strict scrutiny is the absolute highest standard of evaluation in the court system, but undue basis and undue burden are a bit different. They're constitutional tests that are put through by the Supreme Court of the U.S. that were developed in the 19th century that ultimately cite that legislatures can't make laws that are too burdensome or restrictive on the rights of specific individuals. And so in terms of the Casey case, the law is invalid if its purpose or its effect is to place substantial obstacles in the path of a woman seeking an abortion before the fetus attains viability. So ultimately, the court upheld all the provisions of the Pennsylvania statute under the attack except for the requirement of spousal notification, which means that in Pennsylvania specifically, that abortion can happen up to the point of viability, but that the rest of the laws would still be in place, the rest of the statutes. So young people still have to have parental consent. You have to wait 24 hours before your abortion can happen and those kinds of things. So Roe is not necessarily disagreed with in this case. The central clause is upheld because, again, they cite the 9th and 14th Amendments that say that the right to privacy and women's health is a priority and she has those rights under the Constitution. But they do overturn the trimester framework, they overturn strict scrutiny, and they overturn the capability for women to seek an abortion based on the trimester framework.
Thank you. So it's important to, again, going back to the Dobbs ruling, that we say that the Supreme Court basically said states are going to decide. So one misconception that's been put out there in social media is that the Dobbs case made abortion illegal, and that's not accurate. What the Dobbs case basically said is, again, those two things of abortion is not a constitutional right, and again, this is in their majority opinion, is not a constitutional right, and instead the states should decide. So every state gets to decide whether or not abortion is going to be legal or not. And if the states decide it's going to be legal, they get to decide which parameters. So in other words, at which term. So we saw the Mississippi law, and as Professor Zimmerman told us, that's why they chose 15 weeks, because that was dealing with the second trimester. And every state will decide, is it going to be 6 weeks, hearing a heartbeat, whatever the case may be. And also with the majority opinion, we've had a lot of parts of the Constitution that have been, in the Dobbs case, the majority opinion, that have been pointed out in regards to their ruling. So for example, the 9th Amendment, one of the least popular or known amendments, 9th Amendment, essentially just means not all your rights can be listed in the Constitution, because then we'd have a 20,000 page document. You know, it doesn't say you can wear whatever you want to wear, but that's what it's supposed to say. We also have the 14th Amendment's Equal Protection Clause, and you also find it in the Texas Constitution, Article 1, Section 3A, equality under the law. In regards to if basically saying you have the same rights I do. And then also 14th Amendment's right to liberty. And of course, remember the Supreme Court are the official interpreters of the Constitution, so what does life to liberty mean? Right? And we could go around the room and everybody would have a different opinion. Several Supreme Court cases have tried to take on the concept of right to privacy. Griswold versus Connecticut, Lawrence versus Texas have all tackled on the concept of what does right to privacy mean. And in this case, those didn't involve abortion, but simply the broad topic of right to privacy. So Professor Finley, I'll address this question to you. What do the U.S. and Texas Constitution say about the right to privacy?
Well, first let me make a quick point. Since you mentioned the 14th Amendment, today, 28 July 1868, the amendment was certified by Secretary of State Wilson. All the historians are nodding their heads. That's why we teach history for football curriculum. Anyway, back to what does the court say? Well, let's back up a second. Let's see what the Constitution says first. Is there a right to privacy? It's an expectation. It's very American, it's not. Like the right to own a gun, the right to move west. It's sort of expected. But is it guaranteed? Okay. Constitutional powers. We'll talk about this for just a second. There are powers that belong to, most of you are familiar with federalism, divided power, or shared power. There are powers that belong to the national government, and then there are powers that are left to the states. The powers that belong to the national government, of course, are delegated powers. Among these are expressed or enumerated. I'll tell you why I bring that up here in just a second. Also implied as well as inherent. Okay, expressed or enumerated means written down or listed in the Constitution. For example, Article 1, Section 8 says you have the power to lay and collect taxes, declare war, coin money, so on and so on and so on. All right. Implied comes from interpretation by the Supreme Court. Okay, that was based on the McCulloch versus Maryland, the case in 1819. Inherent powers have to do with foreign policy, so we won't touch on that much today. Anyway, enumerated powers are listed, and concurrent powers belong to both the state and the national government. For example, the power to tax. You pay state taxes, you pay federal taxes. And reserve powers are powers that are left to the states. Now, as individuals, you have some rights as well. Civil liberties and civil rights. Civil liberties are protection from the government. Civil rights are protection from discrimination. That's always an easy way for me to remember, and that's why I use that. So back to the right to privacy. Is it guaranteed? Well, like the right to vote, which is also an expectation, I think it's a fair expectation. Speaking of, let me reiterate what Dr. Regalado said, register to vote. Get registered and vote. I don't care how you vote, just vote. Okay. As soon as within 2 months of your 18th birthday, you can register. Those of you who are still in high school. All right. So anyway, back to these. Is it guaranteed? Well, sort of. It's kind of implied. Okay. Anyway, but it's not enumerated. It's not expressed. It's not an enumerated power. Which some of the debate regarding the Dobbs case, or some of the debates surrounding that, was that that there is no right to abortion, there is no right to privacy because it's not spelled out in the Constitution. But then you have other rights that aren't spelled out in the Constitution as well, which come from several amendments, including the Ninth Amendment, which has been discussed up here. But anyway, for example, the First Amendment, the right to worship, okay, privacy of beliefs. The Third Amendment, quartering of soldiers, privacy of home. The Fourth Amendment, unreasonable search and seizure, privacy of person and possessions. All right. Fifth Amendment, self-incrimination, privacy of personal information. Ninth Amendment, rights retained by the people, which I think we discussed already up here just a moment ago. A broader interpretation of privacy. All right. So just because it's not mentioned in the Constitution doesn't mean it doesn't exist. And for the most part, the Supreme Court, up until fairly recently, seemed to go in line or agree with the right to privacy. I mean, we can go all the way back to cases in the early 20s. Throughout most of the 20th century, all the rulings. Early on, the rulings with regard to privacy had to do with education. For example, in 1923, Meyer versus Nebraska, there was concern about teaching German in the classroom. Okay, this is right after World War I. So therefore, if you're teaching German, you're indoctrinating the students and teaching them to be, evil, so forth and so on. And that's followed by a case in I believe it was in Oregon, Pierce versus the Society of Sisters. Had to do with education. As we move through the 20th century, this does more and more focus on some of the things I think we're discussing up here. The right to, mainly has to do with, let's say, intimate relations. Okay, the right to use contraception. Okay, that's Griswold versus Connecticut. The right to possess explicit literature in your home. Okay, that's Kelly versus Johnson. Roe versus Wade, 1973. So the courts seem to be ruling, kind of moving in that direction pretty consistently throughout most of the 20th century. What I think we're seeing here is perhaps a reversal of that. Now the concern is, and maybe this is not the place to address, but the concern is, okay, if they overturn Roe, do they begin to go back and attack some of these other cases that I just mentioned? Which has to do with the right to make sure that the prophylactic police don't come into your bedroom and see that you're using a contraception or something like that, or same-sex unions. Okay, that's a growing concern. So the right to privacy, there's three aspects to it: the right to be free from government intrusion, the right to not have private affairs made public by the government, and the right to be free in thought and beliefs. Those are the aspects. Is it protected? Is it guaranteed? It's up to 5 folks in black robes, rather, that tell you whether it's guaranteed or not.
Thank you. Yes, sir. Thank you. Dr. Hickes, I'd like to address this question to you. If you could talk to us about the mental health and aspect of this, because if you've been following the news, if you didn't hear, in Texas we had a woman that had carried around her dead baby for 2 weeks because she couldn't find anyone in Texas to conduct an abortion. Also, we have this confusion in regards to ectopic pregnancies and the medical aspect, and obviously I'm not a medical expert, but some of these don't involve heartbeats. And then lastly, in Texas, as I stated, there is an exemption for if a woman's life is in danger, but it can get frustrating for medical experts to say, well, if as a doctor I say, okay, her life is in danger, but what does that mean? Does that mean she's about to pass away in an hour? Or does that mean in 3 months if it's not treated? So, Dr. Hicks, if you'll talk to us about the mental health aspect of this, please.
Absolutely. And I would say that in sitting and having this conversation, if you think about yourself as you're thinking and reflecting on what's been said and what's been shared, if you're online thinking about this, think about how many emotions that you have personally had during this conversation. We have some esteemed faculty members here sharing the facts. It's bipartisan. We're not sharing opinions. But think about the emotions that you've just had thinking about this. And so we've been in a pandemic for 2.5 years. And so the pandemic has brought on this mental health crisis. So it's brought on feelings of anxiety, isolation, feelings of depression. And so the fact that this case and the overturn of this case comes during the pandemic, I think that just exacerbates the mental health crisis that we have already been in. And so I'm glad that mental health is a part of this conversation, because we as people have to normalize what that means and really consider our psychological well-being. It doesn't matter which side you're on, but in this case, and you've heard the data today, that 64% believe that it's a constitutional right for people to have an abortion. And so think about that 64% and the strong emotions that they might have. But there's also that 36% as well, and the emotions that they might have. And so from a mental health perspective, I would encourage you and your students and wherever you are in the community to really take stock in that. And so if people are reacting strongly to cases like this, that's okay, that's normal. I would say talk to somebody. If you're a student here, we have free therapy, free counseling for our students. If you're a community member, we have a licensed social worker. You can come and you can learn about the resources that we offer, but do not isolate yourself. We've learned that during this pandemic, that isolation only leads to poor outcomes in regards to our mental health. Also, think about the resources, and if you don't know what the resources are, you're happy to come to what we offer, our student support services, and meet with the social worker. Very confidential conversations, because this issue is so personal to a person, to a family, whether you're a man or a woman or a kid or whatever. It's so personal, and so we can't say exactly what to do and exactly what resources you might need to focus on your mental health, but come to us, have a conversation, and the community is welcome to do that as well. When you look at the research, when you think about abortion and all the cases that we've talked about today, as we've debated the abortion at the state level, at the federal level for many years, there's this conversation about mental health and the impact that's been alongside that the whole time. And so is it detrimental to folks who choose to get an abortion? What about folks who are denied an abortion? What's the mental health impact? And so recent studies show that there are poorer outcomes for women who are denied abortions than those who are able to receive abortion. So there's been some longitudinal studies, and I can provide those resources so folks can see in looking at that. And so most importantly, just have a conversation. Folks don't have to agree with you. If you don't have anybody to talk to in your family, your friend group, come to OC. We'll get you connected with somebody who you can talk to about how you feel about this topic, whatever side you're on, and then we'll get you the appropriate resources that will benefit you and your family.
Thank you. So I want to go back to Professor Finley, and you mentioned the bill that's out there. It hasn't passed, but in regards to protecting same-sex marriage and interracial marriage. Now, in this part, it's an educated guess because it hasn't happened yet. But what's your opinion on that bill? I know it passed the House, but what do the experts say about it passing the Senate?
Well, not likely. There are probably not enough votes there to get it through. I say that. I was listening to an NPR the other morning. There seems to be some movement, but not enough. In other words, they're going to need the 60 votes, and they think they could verify like 55. Okay, but what that is, that's a response to this decision and as I mentioned just a moment ago, all the previous decisions by the court protecting these rights, are they going to be overturned? And so if you legislate them or get statutes on the books, then that doesn't mean that they can't go and still go to the courts, but that makes it more difficult for the court to overturn it. So they're trying to line up protections just in case. And just because the court ruled this way on this one particular instance than Dobbs, there's no guarantee it's going to be. However, based on the makeup of the court as it sits, it's likely, or it's possible. Let me qualify that.
Okay, thank you. So last question I want to address to Professor Clark, because we're seeing, again, a lot of reactions to the ruling. Like Professor Finley mentioned, the national legislation, proposed national legislation to protect same-sex marriage and interracial marriage. We're seeing a case arguing freedom of religion, and this is from the Jewish faith in regards to, does this violate my freedom of religion by not allowing an exemption for if the woman's life is in danger? Remember, as a reminder, the states will decide what exemptions there are, rape, incest, if the woman's life is in danger, if any at all. We also, if you've heard, Austin is trying to decriminalize abortions within city limits. We've had the question of, can states restrict travel? And this is, again, one of those that it's an educated guess, because for example, if the state of Texas bans travel for the purposes of abortion to New Mexico, does that mean the state of Texas can ban you from traveling to Nevada to gamble? Right? And again, there's no answer there, but just kind of some things to think about. The woman in Texas driving in the carpool lane, pregnant, and she gets pulled over and gets a ticket, and she talks about, well, wait a minute, you said that this fetus is a life. And that hasn't been issued, it's just an issue that happened. So we see a lot of arising issues that are occurring. Georgia stopping abortions right now because, there's some potential lawsuits out there. And we have a lot of information overload. I mean, we have all this information. So Professor Clark, as the media literacy expert, can you talk about some of the rising issues, and also how do we sift through, how do we filter through all this information?
Most definitely. Dr. Hicks touched on some amazing things, and I want to reference those as well. She mentioned the 64% versus the 36%, and getting things from all different angles and really thinking about both sides. We talk a lot in media literacy about misinformation versus disinformation, and I don't know about y'all, but every weekend I get something on my phone that says, hey, during the week, this is how many hours per day you spent on your phone. And every week I look at it and I'm a little bit ashamed. But one of the first assignments that we do in my media literacy class is we take stock of how we consume media. And a lot of times we think of media as the news at night, CNN, Fox News, which side you're on. But really, media is anything that you are interacting with. It is a book, it is a TV show, it is a movie, it's a billboard that you see. And then we get into the news side of things. And with the last couple of years being stuck indoors in some instances, people have really found communities online, whether it is on Twitter or TikTok or Facebook or YouTube. And there is information coming at us all the time, and coming at children, at students, at anybody that's consuming that media all the time. We talk about misinformation, and you constantly see things on Facebook, and some of them are funny and some of them are serious, but there's also people out there that share them thinking they're the truth. And when we talk about misinformation, it is something that is shared thinking that it is true, but not trying to be passed off with negative repercussions. This is something that I saw, I thought it was true, I shared it. We talk about disinformation out there, and that is something that somebody puts out there knowing that it is untrue, or that the kernels of truth aren't in there. Those of you that are on TikTok, there is a popular series that is literally called Fact or Cap. and they go through and they pick things and they say, is this actually happening? Is this true? So really one of the things that we talk about literally in media literacy is how to become literate as a consumer of media. So I'll share with you a couple of things as far as how to check your sources and things like that. But when we get into the journalism side, a journalist has 5 values, and they are trying to be honest, independent, fair, diligent, and accountability. And a lot of times when we're talking about stuff that's put out there, it's not so much a journalist putting it out there as it is an entertainment show. And just knowing the main difference in those two can be the start of it. I would like to reference a few of the stories that you mentioned, if you don't mind, and kind of get the panel's opinion or side on them. On the Austin City Council voted to decriminalize abortion. What would that look like from a level of is that possible? How would that be carried out from a historical city versus state versus national? How would that work?
You want to take the
Well, that would be interesting. You know, as the conservative side of things always saying local control, they're screaming local control, but then they override municipal actions when they say they want to ban fracking inside the city limits, for example, or something like that. So I think it would certainly end up in court. It would get challenged. I don't know who would be the first to jump off the gun, be the state government or the feds. Might be both. They might both bring cases into the court system. But it would be challenged. You know, whether Austin they could protect those people, I don't have a good answer for you.
And I know they had done something similar with certain amounts of marijuana recently, and the order was essentially to the cops, just don't charge for it. Yeah. And so I was curious how that would go. Something
like that, it's not quite such a hot button
right.
issue. They probably, you know, it's like, what was it, when I was talking about the possession of explicit literature, I think it was Alaska, where it was legal to own the explicit literature, but not to have any pot in your house. You have the dirty magazines, but not pot. So I mean,
I know that this kind of came really into reality, these cases, back in May when a draft of the Supreme Court's orders or just a draft had come into the public knowledge. Has something like that ever occurred before, a leak in the Supreme Court, if you will?
To my knowledge,
not
no.
that I'm aware of.
And I mean, and then going back to the question you had asked about Austin is like, it goes back to the COVID things, right? And can a city pass, municipal government pass something or a special district, even though the state's saying otherwise? And as I've been telling students is like, well, you're going to listen to who writes your paycheck, right? And if the state gives you more money or the city gives you more money. But to my knowledge, no, it's never happened, a leak as big as this. And as y'all saw, the leak that occurred, there wasn't many changes from the actual summary. And if you didn't know, what happens is once the Supreme Court rules, then they have about 30 days to issue the official ruling where they put out the whys and why I disagree, the dissenting and stuff like that. So August 25th is when the ruling is actually going to go into effect because now the official ruling's been happened. So to my knowledge, I don't think it's ever happened. Professor Zimmerman, Professor Family.
Nothing this big.
The other thing that I wanted to hit on, just from the communications standpoint, we are bombarded with stories, whether it's on Twitter, Facebook, wherever it may be. And what I always challenge students to do is, number one, look at who is giving that information. What is the source on it? And in order to do that, you have to read past the headline. So many times the headline that you see is all that you're going to take from the story. So the first thing that we do is find headlines and read through the story. See where that information is coming from. Is it a reputable source? Is it something that was directly advertised to you? We talk a lot about, based on where you go online, you are going to get stories that are suited for you. If you search for something on Amazon, it's not a coincidence that 24 hours later you get a coupon in your email saying, hey, you should buy that river rafting experience because it's 20% off right now. The tracking that is out there is happening, and so things like that are always important to know whether or not it's been suited to you. TikTok right now is something that I am very, very curious about because it has kind of taken that secretive side and given it to us forward-facing. You literally tell it, I want to see more things of this. I like this. Give me more things. So it's not a coincidence that if you like one dog video, you start getting a dozen other dog videos. And that is awesome. But when you're getting also your personal news from that, if you like something that is in support of this, you're going to start getting stories that are only in support of those. So number one, I always tell students, make sure that you're checking those sources. There's some great websites out there, whether it is AP Fact Check has an amazing Twitter, factcheck.org, even Snopes. I know it's been around for a long time, but there are so many things out there that you can see whether or not this is true. Washington Post does a great fact checker, and then on the political side, PolitiFact also has a really, really good fact checker. But the TikTok, back to it, you end up in your own little ecosystem if you're only listening and only talking to people that are only giving you things that they know you like. And you have told TikTok either by commenting or by sharing or by clicking on, this is the stuff that I like. So you kind of lose that other point of view sometimes, and that can be very, very dangerous for people. The other thing that I did want to touch on, I think I touched on it all, actually.
Can I add something?
Please, jump in.
So Professor Clark has talked about social media, media literacy, and told us how we can really think about what's coming to us. But from a psychological perspective, it's okay to turn those things off. If you continue to have strong emotions when you're watching whatever news outlet, or you're on TikTok and your little multiverse on TikTok, you can turn that off for a little bit and step away, because that'll help with some of your mental health well-beings. We've had to do that during the pandemic as well, and so as we're watching what's happening with the cases and all of that. So similar thing here, if there's a strong emotional reaction, just take a break a little bit, or maybe you put the hashtag cute dogs or something, and then that you're just looking at cute dogs for a little bit and not all of these strongly emotionally connected things.
Agreed 100%. Yeah. Get away from it from time to time.
Okay, I think we are out of time. So with that being said, thank you for attending either physically or virtually the first episode of OC's new series called Order in the Court. We hope that we presented an unbiased, factual material to you. And just last thing I want to say is, when somebody had posed a question online, how do I get exposed to some of these resources, stuff like that, plug for the Social Science and Communications Department, take government so you can learn about these things, take history so we can learn about the why, and then take media literacy, communication, so that you can learn how to sift through that information. But I appreciate you. Thank you, panelists. Thank you, audience. Y'all have an amazing day.